So it turns out that we actually have day jobs that we do when we're not answering people's questions, which is handling a lot of cases
I was
for.
really upset that we had to work this week.
I know it's a bit of a pain, but it does happen. So unfortunately, for this Friday and the next Friday, we're in mediations. We're traveling to see clients, so unfortunately, we can't come live. But we did want to still be able to answer some questions, so we thought we'd jump on and knock out a few questions.
I'd also like to encourage anybody that was looking forward to our lives, which we're going to continue after the next 2 weeks. Please text any of your questions. You can call the number that's on the screen and leave messages with producer Eric, and he'll make sure that we address those in the next show or two.
Yeah, and we get comments all week long, and Eric and I look at them. You look at them when we sit down to do this, and yeah, go ahead and put them in there. We'll see them and we'll answer them.
Well, let's be clear. Most of the questions we just are hearing for the first time while we're talking. And so, again, we give the admonition that people should seek their own independent legal advice. We're just getting them in the ballpark. It's something that for them to consider. And we highly recommend that if you have a trust and estate matter or any type of matter, a personal injury matter, you name it, is to define that matter in a Google search or some type of AI search and find what lawyers are qualified to actually handle your case. But we will definitely head you in the right direction.
Yeah, absolutely. And our advice is always worth the money you pay for it.
Yeah,
So
you guys know enough to be dangerous. That's what you
yeah,
said before.
that's right.
So
Yeah.
you can roll with that.
I really
Yeah.
don't know what I'm doing. I'm just really confident.
Cool. All right. Well, let's jump into it then. Here's the first one that we got. I got this shortly after our episode last week. We had a listener ask, after requesting a formal accounting, does that automatically allow a beneficiary the power of subpoena?
Oh my God, do I wish.
Yeah, I wish too. I know that'd be so nice. No, the answer is no. I mean, I don't know what you mean by requesting. So if by requesting you mean that you filed a petition in court and you asked the court to order an accounting, yeah, maybe, because now you have an active court case. And as a lawyer, we can issue subpoenas in an active court case. If you mean that you shot off a letter or an email saying, hey, I want a formal accounting, now can I issue subpoenas? No. No, you have to have some sort of legal action pending within which to file or issue subpoenas and have access to what really is just the Discovery Act is what you're doing. You're just making use of the Discovery Act, but you can't do it outside of a lawsuit.
You got to have a lawsuit filed to get a subpoena. And I can't remember which mob movie it is, but there's a mob movie where I think it's Don Corleone is saying to, one of his
it is Godfather
lieutenants, his Godfather, Godfather better than I do, but one of his lieutenants, he's saying, give me one good lawyer, and that's better than 100 of my henchmen. And the reason for that is that lawyers are given great power under law, under the civil Code for Civil Procedure, the Discovery Act, and we're entitled to get into a lot of information from people that they normally wouldn't be required to disclose. So once a lawsuit's filed, there's some waiting time periods that there's a discovery hold period of a certain amount of time, but then you can issue subpoenas, take depositions. You can literally require somebody to sit across from you and answer your questions. It's a very powerful position to be in, but unfortunately you can't just issue subpoenas without a legal action being filed.
No, exactly.
Cool. Thank you, guys. Here's another one. This is a seminal case. I had to look this up, but it was here in San Diego in the past. Our listener was curious, in the Leader versus Cords case, was Terry Cords found to have acted in bad faith?
So I don't know the answer to that question, and maybe Keith does. But first of all, Leader versus Cords, what the case stands for is that a trustee doesn't only have the duty to account to the trust beneficiaries for what's in the trust and how much, what are the assets, what are the liabilities, how much money that the various beneficiaries should receive. It's so funny. When we have a conversation like this, you're like piercing your eyes through me, which you normally don't.
Oh, sorry.
You normally don't do during a normal
really paying
conversation.
attention.
You're just like,
really,
what's he going to say next?
Yeah.
So I'm like, am I saying this wrong?
No, it's over.
So the beneficiaries are entitled to an accounting. And so, but what Leader versus Courts really does is it stands for, you can look at me, Keith. Okay. What Leader versus Courts really says
I'll try not to make it look like I want to kill you.
Yeah. You look like an interrogator. You would do well in the KGB.
Yeah,
You just walk into the room and start staring at people. They're just like,
yes.
But So what Leader versus Cords really did was it said that the trustee has a duty to deliver the assets to the trust beneficiaries. So how does this come up? A very controlling trustee takes over, doesn't like their brothers and sisters, and wants to be difficult to deal with, and says, oh, I've got the money, I'm just not going to make any distributions right now. And that's not the trustee's job. The trustee's job is to account for the assets, pay off all the creditors, and make distributions in most plain vanilla trusts. Some trusts, they have discretion, but the mandatory blow-through trusts where you got to make a distribution, they've got to make these distributions, and they don't. And so Leader versus Cord says, no, you can't do that. You can't just hang on to all these assets. You have a duty to account. That's wonderful. That's good. But you also have a duty to distribute assets to the beneficiaries. And that could be a preliminary distribution. It could be a final distribution. You just can't hang on to millions and millions of dollars and not make a distribution. You can hold a reasonable reserve. And I don't know if Leader versus Cord goes into that, but you can hold a reasonable reserve as a trustee to pay for outstanding, tax liabilities or your attorney's fees or whatever the case may be. But you can't just simply hang on to the assets. The question about bad faith really goes to a provision in the probate code that says if a beneficiary or a trustee, either one, does something with an accounting in bad faith, the judge has a right to shift the bad acting or the rightful party's attorney's fees to the bad acting party. And that could be either or. So if you're a beneficiary, why don't you walk us through this, Keith? If you're a beneficiary, how do you act in bad faith? And if you're a trustee, how do you act in bad faith?
It's a very difficult question to answer just because bad faith is a little bit of a nebulous concept. What exactly does that mean? And it's completely at the discretion of the trial judge. And so the judge gets to decide if it was bad faith or not. But typically bad faith means that you've done something above and beyond just objecting to an accounting. So whether you're a beneficiary or trustee, if you object to that accounting in bad faith, meaning you're doing it for reasons that aren't legitimate to the accounting, you're doing it to try and cause people, problems, or, a trustee is just trying to abuse their position. So a lot of times, judges will point to the actions that the trustee takes during the litigation. If they just, they go too far in terms of what they're doing, or, they take, 50 depositions and it's a case where they're litigating over $10,000 or something along those lines, where it just seems very excessive. But it's hard to answer the question of what is bad faith, because it's kind of like, I forget which Supreme Court justice it was when they were trying to decide on pornography. And the justice says, well, I can't describe it, but I know it when I see it. I know the difference between art and pornography when I see it. Mm-hmm. And bad faith is kind of the same way, as the judge knows it when he or she sees it. Mm-hmm. But if you come to me as a client, or the client goes to you and says, okay, here's what's going on. Is that bad faith? It could be, or it could not be. I don't know. But it doesn't matter. You have to argue bad faith. If you want to try and get attorney's fees, you have to argue that the other person acted in bad faith. And that leads us to a broader discussion of, why a lot of times people come in and they think, well, I should be paid my attorney's fees. I wouldn't have had to do this if this trustee wasn't bad and doing the things that the trustee shouldn't be doing. And I think people are really shocked at how rarely courts will award attorney's fees. And that's kind of a more broad discussion of why is that? Why is it that judges are reluctant to shift attorney's fees? In the American system, everybody pays for their own attorney's fees, whether you win, lose, or draw, which apparently is very different from like the United Kingdom, where the winner by law gets their attorney's fees. So our system is based on this idea that everybody has to pay their own, except for limited exceptions. And I think a lot of judges, at least in my opinion, they see the shifting of attorney's fees as being punitive. And so they'll do it, but only in situations where they feel like it's the right solution to the problem, not because you had to come in and do something because this trustee is being difficult, but because there was something more than that. I think the judges want to see something more than that in order to shift attorney's fees. But what are your views on that?
Well, so the general rule is you're going to have to pay your own attorney's fees. So
right.
People should just assume that's going to happen like 90% of the time. There are two exceptions. One is statutory in nature and the other is contractual in nature. So if there's a contract that you sign with another party that says if you're the prevailing party in a litigation in the future, because you don't know if you're going into litigation or not when you're signing the contract, that the prevailing party gets their attorney's fees. So the court has authority at that point to follow the terms of the contract that you entered into with another person. And if you're the loser in that case, you're likely going to have to pay the attorney's fees of the prevailing party. And there's a prevailing party. I mean, just for definitions here, it's the person who wins, but there's an analysis that takes place there of who's a prevailing party. Because sometimes you win part of the case, but not the other. Are you the prevailing party? So you look at some rules there. But ultimately, just keep in mind that if you win the case and it's under contract. The other thing is there's some statutes out there that allow for the attorney's fees to the winning party. If they win and are successful, they get their attorney's fees paid. So those are out there. Financial elder abuse is a good example. The financial elder abuse statute, which is put in place to protect elders over 65, where there's an exercise of undue influence over that elder to take their assets away somehow, some way, whether it's through an estate plan or a will or a trust or whatever. If you take an elder's assets, anyone that's over 65, and somebody sues you for that and you lose that case, you're not only going to have to return those assets, but you're going to get hit with their attorney's fees. And so that's how that generally works.
That probably happens more when the elder is still alive. But when we bring financial elder abuse once the elder is deceased, I think it becomes much more difficult to get your attorney's fees once the elder's passed. Because again, I think the judge is looking at this saying, well, these are two parties, they're fighting over assets. You know, yeah, you had to incur attorney's fees, but so did the other side. You know, you all have been kind of equally damaged in that regard. We just don't see courts shifting attorney's fees with the exception of contractual obligations. That's different. But we don't see it happening that often. And the problem is, I think most people think it should happen and it doesn't. And unfortunately, I think there's attorneys out there who will tell people, yeah, I'll get your attorney's fees for you. They won't. 9 times out of 10, they won't. And so I think it's at least good to be honest about it up front. Is that, yes, you can ask for it. And yes, we can argue for it, but you should assume you won't get it. And that way you won't be disappointed.
Well, and I mean, really what it comes down to is you don't do very well at your arguing for attorney's fees. I've listened to you ask for them and you do terribly. So that's probably,
is that the problem?
That's probably the reason why you're not, you know, so that's, no, I say that tongue in cheek because that's probably how clients feel, because they say, well, the statute says I get my attorney's fees. How come I didn't get them? And as you pointed out, and rightfully pointed out, judges just are reluctant, at least in the financial elder abuse arena. And it's strange to me that they are.
Or even bad faith.
Even bad faith. They just don't seem to do it as often. Now, I am seeing more and more judges doing it. I'm also seeing more and more awarding attorney's fees. I'm also seeing more and more judges issuing sanctions against bad acting attorneys who refuse to answer discovery. Discovery is, you know, it's, you might as well take 2 pencils and stab them in your eyes, and that's better than going through a discovery fight. Many times you get such sloppy answers, you just got to set up depositions and take depositions to figure out what's going on. But the written discovery is really nasty, but we're seeing more and more judges issuing sanctions, and they're not huge sanctions, but even a $500 or $1,000 sanction, it gets the attention of the bad acting attorney.
Yeah. And I mean, I think the more the courts do that, the better. But yeah, it just be aware that it's not such a sure thing like people think it is. We love leaders v. Cords. We've used that case tons of times in order to force distributions, because you have these trustees who simply don't want to make distributions. And Leader versus Cords is a great case in that regard.
Yeah, there's actually a sentence in Leaders versus Cord that we use in our motions. It's in there. You'll find it. And it says it's not just the duty, something to the effect of, it's not just the duty to account, it's the duty to deliver. And it's such a powerful sentence.
Yeah, it really is. And I don't know specifically if they found bad faith in Leader v. Cords, but I do know that the court awarded attorney's fees. And there's a concept under appellate law that if the court awards a certain result, then there's an assumption that they found all the elements that they needed to find in order to get to that award. So if they awarded attorney's fees, there's an assumption that the court did find bad faith. So, you know, I'm assuming that happened. But
and this raises a whole nother discussion that we don't need to have right now, and that is appeals.
Yeah.
You know, many people feel like if you lose, well, the appellate court's going to get it right. Keep in mind that appellate courts actually look for ways anyway to substantiate what the trial court did, to affirm what the trial court did. And so most appeals are dead on arrival. So, you know, your time to win a case really is at the trial court level. And I take it one step further, your place to win a case is in mediation. And that's not because you're being afraid of going in and actually trying the case. It's just that there's going to be somebody that's really unhappy with the result that a judge or a jury comes up with. And so it's almost always better to take control of the case in mediation if you can. So don't go all the way to appeal. Appeal, by the way, if you go all the way to appeal, you're talking years and years of litigation.
Yeah.
And then in many cases, the appellate court we'll send the case back to the trial court and have the case retried or a portion of the case retried, and that opens up another can of worms.
Yeah, it really does. We should have a whole episode just on mediations and settlement and stuff, because there's a lot of important concepts there that we could talk about quite a bit.
Yeah.
Noted. Cool. We can do that. I know I've read a lot of the documentation and stuff that we're revising and sending out to clients. So yeah, I've read up, and it's a lot of info, and yeah, I think it'd be some great topics to cover there. Here's a comment that was on our latest video about the Liz Pendens kind of breakthrough case. Our listener said that's progress because of the privacy elements inherent to trusts. This factor will hopefully prevent or deter untrustworthy trustees from creating more havoc by selling disputed real property. Are they on the right track there? They also went on to say, is this only in California as well?
Well, the case we were talking about was only California, and we're only California lawyers, so we can't speak to other states. But yeah, they are on the right track. I think that allowing litigants to use a Liz Pendens or a litigation lien will prevent havoc by a trustee selling something or refinancing something without the issues being resolved. And the more that we can kind of maintain the status quo while the dispute's ongoing, the better. And like I said during that episode, sometimes we actually negotiate, okay, we do want to sell this, but let's all agree that the sales proceeds will be locked away and secured somehow. And that's something that everybody can agree to. That's a good thing. But just letting a trustee act how they want to act, especially if it's a bad trustee, it's not good.
Well, keep in mind, there's also an arbitrage we can do now that we couldn't fully do before, and that is when you have a Liz Pendens filed prior to this hearing that we talked about. And the hearing said, you as a beneficiary of a trust have a right to file or record a Liz Pendens, which keeps property from being refinanced or sold during the pendency of a litigation over the title to that property. And you as a beneficiary, even though you only have an equitable interest in that property, not a legal interest, you have the right to file that lien essentially against the property. The thing I like about it is now, it used to be that if you filed a Liz Pendens and you damage the trustee's right to sell the property and the seller goes away and then they have to sell it for less later on, the trustee makes a claim against the beneficiary for the loss in value and the damages for interrupting that good sale that was going to happen. And so what I would say is we would file or record a Liz Pendens, and if the opposing lawyer comes back and says, hey, you need to remove that because we have a sale going on, we'll say, great, I'm glad you have a sale going on. We're willing to remove it if we're willing to talk about blocking the proceeds that come out so the trustee can't willy-nilly take them and do whatever they want with. And of course, you have to be reasonable there. If the trustee has expenses, sometimes we have a cash poor estate and they need cash to run the administration. Well, maybe a small portion of the money could come out to be used for paying taxes or filing tax returns or paying lawyers and things like that, but not the whole amount where the trustee could abuse these proceeds and go on and do things with them they shouldn't do.
Yeah. And then now you have the opportunity to do that. That's fantastic.
Okay, next up we have a scenario. It's it's tough to surmise. There's a lot of info in it, but I'll briefly kind of go over it. Our listener, her father passes away, and essentially her stepmother goes and redoes the trust and makes an amendment to it, and she gets this done by a drafting attorney who is also like a family friend, and it seems like a whole kind of messy blended family situation. She also told me, yes, I'm feeling a little like Cinderella at this point, being kind of forgotten about by this step family who is essentially getting all the assets and the things in the trust from her own father.
Yeah, I mean, the bottom line there is dad made a huge mistake, and we see this so often. I mean, back when we used to do estate planning, I would see it. Now that we do litigation, we see it. So you have this married couple, it's a second or later marriage. They have kids from prior marriage. Dad leaves everything to his wife. He dies. Now it's wife's property. She can do whatever she wants with it. It doesn't matter that it was dad's house. It doesn't matter that it was the house that you grew up in. It doesn't matter that the house was given to dad by his mom and his mom got it from her mom or dad. You'll see these generational properties going down, and all of a sudden it all goes, south because dad left everything to his wife. And once he did that, game over. The wife can do whatever she wants. It was just bad planning. And what dad should have done is created a trust that puts his share of the assets into an irrevocable trust that benefits wife but doesn't give it to her outright. And now the children of dad have some rights that they can enforce. But people just don't know what they're doing. They're not informed of these things. They'll go to an estate planning attorney sometimes, and the estate planning attorney is only thinking about taxes, not about how does this going to affect the kids after dad dies. And so there's really two main reasons why you do estate planning. One is tax, although now that's less of an issue with the estate tax limit up at 13.9 million per person. And number two is control. If you want to make sure that your assets go where you want them to go, then you better figure that out as part of your trust, especially if you're married and you have kids from a prior marriage. You better be using some sort of a bypass trust, a disclaimer, not disclaimer trust, but some sort of a marital trust or bypass trust to lock those assets up and preserve them for your children, or else it's not going to happen. And I could see where somebody who's asking this question feels very aggrieved because she's saying, this is dad's property. It's supposed to go to me. Well, dad made a huge mistake.
Yeah, and one other thing we see is it's kind of the luck of the draw of who you choose as your estate planning lawyer. We've seen estate planning lawyers that we've come across time and time again, and it seems like they use the same form for all of their clients. And so if they're used to just giving an outright gift to the surviving spouse, which makes sense in a marriage, one-time marriage with a family, but once you get a blended family where there's children from both mom and dad that are different, if dad or mom gives everything to dad or mom, then the survivor of the two can do whatever they want with those assets, as you pointed out. So be careful. If you're doing estate planning, make sure that you're thinking about those things because they do come up to bite everyone in the rear at the end of the day.
Yeah, there's nothing more disheartening than doing a consultation with somebody who's in this situation. It's like, well, let's look at the trust. I'm just hoping and praying there's a bypass trust, a marital trust, and there isn't. And, then you have to deliver the bad news of there's not much we can do.
Yeah.
So is there anything in the fact that the drafting attorney is our listeners, her step family, it's another sister-in-law. So it's like almost their family, the step family's family, who is the drafting attorney. And then, the stepmother is saying that, our listener and her dad always fought and she got whatever she wanted. Is there anything of merit in that or value?
Not really. I mean, if the stepmom has the right to amend the trust because it was left to her in either in a survivor's trust, it all comes down to the amendment and revocation rights. And if the stepmom has the right to amend the trust, she can amend it any way she likes. And she can use anybody she likes. And she can do it for any reason she likes. The only thing that would stop that is if there's a portion of the trust that's irrevocable, that stepmom cannot revoke. That's really the only thing that would stop it. And so you'd have to look at the trust document. But it sounds to me like if this is a completely revocable and amendable trust, the fact that stepmom's using a family friend or who knows who, and that stepmom's justifying it by creating fights that never really happened, it doesn't really matter because stepmom can do it for any reason or no reason at all. That's the heartbreaking part about these cases. They really are unjust in that sense, but there's little we can do if dad didn't do the right type of planning.
Yeah.
One thing I also see, Eric, is the beneficiaries. Let's say that it's their dad passes away and they've got a stepmom, and stepmom still has 2 or 3 years to live, and they start just, at nighttime they can't sleep because they're thinking about stepmom taking all their assets away. So they start harassing stepmom for information pertaining to the trust that she's completely in charge of. These are her assets. And so if they hadn't harassed her and just allowed and it's hard because you want knowledge, you want understanding, but just don't harass her. When she passes away, you may be pleasantly surprised to find out she left the trust in place just like she and your dad set it up. And therefore, you're going to get a share of her trust. But the minute you start harassing her, well, now she starts asking questions. She starts telling her kids about it. Naturally, they're sent to an attorney, whether it's somebody that's in the family or not. And there's an amendment made to the survivor's portion, or maybe to the whole trust if she has a right to do that. And by the way, we're saying this for she, and we're not trying to be sexist here. Generally, women live longer than men. That's been our experience. And so it usually comes down to the mom. But there are cases where mom passes away first. Same rules apply. Don't harass the surviving dad. If he's not your dad, he's your stepdad. Don't harass him. Let the process play out. When he passes away, then you get a copy of the trust and you determine what your rights are from there.
Yeah.
Gotcha. That helps. Yeah. And sometimes it seems like things can just be unjust, unfortunately. And yeah, I mean, we can't assume what is happening in this relationship, but we empathize for sure. Okay, I got one more scenario, and then maybe we can get to some news. I'm just gonna read this one out. Hopefully, it's not as complicated. Keith, I think I gotta start using like just fictional names because it helps understand the family tree better. I know you do it when you write blogs and stuff, so it's like
Yeah, it helps.
it's tough to say a stepsister's sister-in-law what the relationship is, but anywho, okay, this listener wants to know what is a reasonable time to wait for the final distribution from a trust. I've read that for trusts which aren't complex, it might take 12 to 18 months. Would it be wise to wait an additional 6 months, making it 24 months in total before I file a petition to compel distribution? I'm hesitant to file so soon because I'm concerned that my trustee might cite administrative reasons for the delay. I want to give the trustee enough time so they can't excuse any further delay in distribution. The trust specifies outright distribution. Any thoughts there on that kind of timeline?
Yeah, I mean, I think if you have an estate that's not subject to estate tax, so you're not doing a estate tax return, and it doesn't have some other complicated like litigation issue or something, I think distribution within 12, maybe at the outside 18 months is reasonable. I think you go over 12 months, I wouldn't hesitate to file a petition at the 18-month mark. I don't think you have to go all the way to 24 months to get a petition on file. And who knows? I mean, the trustee might come in and say, well, I've had all these problems. Well, fine. But, you haven't been telling us that, and we don't understand why this is taking so long. And it never hurts just to put it in front of the judge so that, the trustee has has her feet or his or her feet held to the fire in order to make sure those distributions will happen. But I wouldn't hesitate after 12 months. I certainly wouldn't hesitate after 18 months unless there's something unique about that estate.
Yeah, I think Keith covered it.
Cool. Yeah. So no magic answer, no magic, time where you should or shouldn't do something. Cool.
There's not a bright line rule. The rule is reasonable. And then the question becomes, well, what's reasonable? And most, I think, judges will say within 12 months, it seems reasonable on a simple estate that's not an estate tax return, or 18 if there is an estate tax return. You get beyond those dates, I think most judges are going to say, what's going on here? This doesn't seem right.
Mm-hmm. Okay. Well, we got a couple, news stories maybe we could hit on. Stuart, I know you at least looked over the filings, at least for a second, on this juicy Fox Sports lawsuit, involved some of the on-camera talent and personalities. What'd you find in this?
Well, Skip Bayless, I personally don't like Skip Bayless. I think he is an opinionated jerk, and he runs players down that he has no business running down. He never played professional sports that I'm aware of. And he talks as if he is talking from a place of knowledge, and he talks down about a lot of these players. And I think it got to the point where he and Shannon Sharp were on, was it Undisputed or something, and they even had differences. And Shannon Sharp seems like, he's kind of a loudmouth too, but he's a funny guy to listen to and a nice guy from what it appears. But what this comes down to is the Skip Bayless apparently offered $1.5 million, according to the complaint, to have sex with the hairdresser at Fox News there that got the talent ready. And she, to her credit, according to her lawsuit, declined multiple times to have sex with Skip Bayless for $1.5 million. I mean, I probably would have sex with Skip Bayless for $1.5 million.
I thought the $1.5 million was outrageous. And then I saw a picture of him because I didn't know who he was. Yeah. And I'm like, he might have to pay more.
So anyway, this is going on now. We just talked a few minutes ago, Eric, about attorney's fees and how you can use statute to force the other side to settle a case. Here, not only did they file a class action against Fox News for also some wage issues, but this type of claim that's being filed by this hairdresser who worked for Fox News, if she wins even just a little bit of it, the court can shift her attorney's fees to the losing party here, Fox News, Skip Bayless, and whoever. Because interestingly, they filed against the entities, Fox News and so forth. They also filed against Skip Bayless personally, which is, so he's going to have to figure out, what he's going to do from a settlement standpoint. So if Skip Bayless says, nope, we're taking this to trial, and Fox says, nope, we're taking this to trial, and they lose by any amount, really, but let's assume they lose by a couple $1,000,000, which this case is worth more than a couple $1,000,000, then their attorney's fees for this hairdresser, which could easily be, if all the way to trial, could easily be $2, $4, $5, $6 million. Those get shifted to the losing party. So what's going to happen here is you're going to see a lot of bluster and pounding the chest by the defendants here, saying they're going to fight this, and this is despicable, and this is horrible. And as soon as the story dies down a little bit, there will more than likely be a settlement, a payment made to the hairdresser, more than $1.5 million, and everyone will move on with their lives. That's my prediction.
Yeah, and rightly so. I mean, I can't imagine what it'd be like to be a hairdresser in that situation. And you're dealing with somebody who's, he sounds like a difficult person, some old gross guy. It's like, I don't understand it. Like, I understand why people do that. Just leave her alone.
Yeah.
There's also another part of it. I don't know if you got to this, but I think this hairdresser, she kind of confided in one of the female hosts. Her name is Joy Taylor. And, she didn't do much to comfort her. And now there's these allegations of this woman, Taylor, doing a sort of a quid pro quo to get to the point where she is, and having relationships with one of the big FS1 Fox Sports executives to get her position. So that's also an interesting kind of piece of it that we're going to keep our eye on.
Yeah, and just keep in mind too that this is a complaint filed by the hairdresser, so we have to give everybody the opportunity to respond. I did read the claims made. I guess the hairdresser ran into this individual and another individual out to dinner or something, and there was something, she knew that there was something kind of off about their relationship from her standpoint. Now, this is all according to her. So let's give the defendants the right to get their answers on, and discovery and depositions and all of that stuff that flows from there. But again, most of these cases, they'll end up settling, and I think this one will settle as well.
But yeah, we'll keep our eyes on it, or maybe dig into some pleadings and things like that. But yeah, our listeners can let us know if that's something of interest to them. There was another one. Maybe we'll tease it and kind of get some more info next time. But Blake Lively is in a lawsuit with a co-star on another movie coming out. The guy's name is Justin Baldoni. And I think this one's very interesting. It's kind of similar to the Vanderpump stuff that we covered. There's some sexual harassment involved. There's a retaliatory, defamatory claims going out, a smear campaign back against Blake Lively. It seems really interesting. So yeah, again, if our listeners want to hear about that one, I'll get the info to Keith and Stewart so we can study that as well. But,
I think also Justin Baldoni, is that his name?
Yeah.
I think he just filed a suit against the New York Times for like $250 million because essentially his argument is that they just took Blake Lively's side of this, never even asked him what his opinion was. Apparently she has some text messages, though, that everyone's surprised how she would have got these text messages, and they're very damaging. But maybe, again, if you put context to those text messages, maybe they're not as damaging. And I think that's what this Justin guy is saying. He's saying the New York Times didn't do due diligence on their story. Maybe they did. Again, this all has to be worked out, but this really blew up. And also keep in mind, this is also filed in California, the case with Blake Lively. And keep in mind that also is an attorney's fees provision under statute. So that'll be, again, one of those minority cases where the loser here may end up having to pay the attorney's fees of the winner. That really gets people to focus on settlement.
Okay.
I feel like every article I read about that situation makes me more confused because each side has lawyered up.
Yeah.
So the lawyers are making all these different allegations back and forth. And then each side has this PR team.
Yes.
Each side's doing media blitzes.
Yes.
And apparently on that New York Times article, they tried to reach out to Baldoni's lawyer, but they reached out at like 9:30 at night and only gave him until like the next morning to respond, which is no time to respond at all. But I just feel like each side is doing such a huge media PR blitz that trying to get to the real core of what really is happening here, like, I don't feel like I understand really what's going on.
Right.
Even though I've read multiple articles on it, it's like I'm getting more and more confused.
Yeah. There appear to be some people that are coming out, and there's even old footage that I've seen that tends to make one think that Blake Lively may be difficult to work with.
Mm.
But, as all professionals, I'm sure Tom Cruise is difficult to work with, but yet he puts out a superior product, and I'm sure he has high demands. But the PR, as you pointed out, going back and forth here, is Blake Lively a nice person? Is she not a nice person? I mean, you're getting assassinated essentially if you're
Yeah.
Blake Lively, and also this what's his name?
Baldoni.
Justin.
Yeah, he's going to be assassinated. His character will be assassinated.
Oh, totally.
And so, yeah, everybody's going to look bad here. What's funny is they're both very good-looking people, and
Yeah.
I guess the suit arises from some sexual harassment and on the set, and it's just it's crazy to think about.
Yeah, it really is a scorched earth campaign by both sides so far, based on what we can see.
And the movie's still there. You can see it's like in the top 10 on Netflix or Apple TV. I can't
Right.
remember, but
Well, we'll see if we can get more information and make some sense of it. But like I said, the more I read about it, the more confused I get. It's hard to really untangle the truth on this one. And I would imagine that from at least some people's perspective, probably any actor is difficult to work with. I mean, it's a creative field and endeavor, and I can't imagine how people put up with the pressure of being on set, because they're on set for like 14, 16 hours a day.
yeah.
I mean, I'm sure I'd be difficult to deal with under those circumstances.
You're not even an actor, and you are difficult to
Well,
deal
there you
with.
go.
So, I mean, let's just
Unlike yourself, because you're a pleasure.
thank you. I'm
You're a
glad.
pleasure to
You're
deal
the
with.
first person to ever say that.
Yes. And I'm not being sarcastic either. I mean it.
Cool. Well, great. I think that's all we got. Good show, guys.
All
All
right.
right. Thanks,
thank you.
producer Eric.
Alrighty. We'll see you guys.